Hello, I am Dr. K. Mishra from our classes. I welcome you all to my YouTube channel, our classes. In series of dealing with Indian legal system, today here I will be talking about writs of the Constitution of India, part 2nd. Writs of certiorari. Literally, certiorari means to be certified. The writ of certiorari is issued by the Supreme Court to some inferior court or tribunal to transfer the matter to it or to some other superior authority for proper consideration. The writ of certiorari can be issued by the Supreme Court or any high court for quashing the order already passed by an inferior court. In other words, while the prohibition is available at the earlier stage, certiorari is available on similar grounds at a later stage. It can also be said that the writ of prohibition is available during the tendency of proceedings before a subordinate court. Certiorari can be restored to only after the order or decision has been announced. In province of Bombay versus Kusanda's case, this is one of the famous cases. In this case, it was held that whenever any body or person having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially acts in excess of their legal authority, a writ of certiorari will lies. It does not lie to remove merely ministerial act or to remove or cancel executive administrative acts. It lies on judicial bodies. One of the fundamental principles in regard to the issuing of a writ of certiorari is that the writ can be availed of only to remove or to adjudicate upon the validity of judicial acts. The expression judicial acts includes the exercise of quasi-judicial functions by administrative bodies or authorities or persons obliged to exercise such functions, and is used in contrast which are purely ministerial acts. The writ of certiorari can be issued to judicial and quasi-judicial body on the following grounds. 1. Where there is want or excess of jurisdiction. The writ of certiorari is issued to a body performing judicial or quasi-judicial function for correcting errors of the jurisdiction. When an inferior court or tribunal acts without jurisdiction or in excess of it or fails to exercise it, the want of jurisdiction may arise from the nature of subject matter, so that the inferior court has no authority to enter on the inquiry or upon some part of it. Want of jurisdiction may also arise from absence of some preliminary proceeding or upon the existence of some particular facts which are necessary to the exercise of the court's power, and the court wrongly assumed that the particular condition exists. Number 2. For correcting error of law apparent on the face of record, the writ is also issued for correcting an error of law apparent on the face of record. It cannot be issued to correct an error of fact. What is an error of law apparent on the face of record is to be decided by the courts on the facts of each case. Now, writ of mandamus. Mandamus is a Latin word which means we command. Mandamus is an order from a superior court to a lower court or tribunal or public authority to perform an act which falls within its duty. It is issued to secure the performance of public duties and to enforce private rights withheld by the public authorities. Simply, it is a writ issued to a public official to do a thing which is a part of his official duty, but which he has failed to do so far. This writ cannot be claimed as a matter of right. It is the discretionary power of a court to issue such writs. The primary purpose of this writ is to make the government machinery work properly. An order of mandamus is a command directed to any person, corporation, or an inferior tribunal, requiring them to do some particular thing which pertains to their or his office and which is in the nature of a public duty. The public servants are responsible to the public for the lawfulness of their public duties and their actions under it. If a public authority fails to do what is required under law or does beyond what was to be done, a writ of mandamus may be issued to make him do what was required under law. When will it will not lie? The writ of mandamus cannot be granted in case of following circumstances. 1. When the duty is merely discretionary. 2. Against a private individual or any private organization because they are not entrusted with public duty. 3. A writ of mandamus cannot be granted to enforce an obligation arising out of contract. When it will lie? Thus the writ or order in the nature of mandamus would be issued when there is a failure to perform a mandatory duty. But even in the cases of alleged breaches of mandatory duty, the party must show that he has made a distinct demand to enforce the duty and demand was met with refusal. The writ of mandamus can only be granted when there is in the applicant a right to compel the performance of some duty cast upon the authority. The duty sought to be enforced must be a public duty and not a private duty. Thus, writ of mandamus can be issued to a public authority to restrain it from acting under a law which has been declared unconstitutional. The writ of mandamus can be granted only in cases where there is a statutory duty imposed upon the officer concerned and there is a failure on the part of that officer to discharge the statutory obligation. Now, writ of Covariant. The word Covariant literally means by what warrants. It is a writ issued with a view to restraining a person from acting in a public office to which he is not entitled. The writ of Covariant is issued to prevent illegal assumption of any public office or usurpation of any public office by anybody. For example, a person of 62 years has been appointed to fill a public office whereas the retirement age is 60 years. Now the appropriate High Court has a right to issue a writ of Covariant against the person and declare the office vacant. A writ of Covariant can be claimed by a person if he satisfies the court that 1. The office in question is public office. 2. It is held by a person without legal authority. The writ of Covariant is not issued in respect of an office of a private character. Thus, in Jamalpur Arya Samaj Sabha versus Dr. D. Ram, in this case it was held that the High Court refused to issue a writ Covariant against the members of the working committee on the Bihar Arya Samaj Sabha, a private association. The meaning of the term Covariant is by what authority. The writ of Covariant may be issued against a person holding a public office or governmental privilege. The issue of summons is followed by legal proceedings, during which an individual's right to hold an office or governmental privilege is challenged. So this was all about this video tutorial. Again, this was important one from different competitive viewpoints and for the legal professionals, students, those legal education students, they really need to know this in detail. I hope that you have liked it, and if you have liked it, please do not forget to subscribe and press the bell button and pass it on to others, those who are needy now and in the future. Thank you. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.